Okay, hi everybody. I'm Helen Gibson from Agencia, and I'm delighted to be joined by Majid Hassan from Capsticks, and I'll just say a little bit more about the two of us in a moment. But it's great to have this opportunity to share with you about our work in the painkiller addiction field, and particularly the emphasis that we're going to talk about today, which is around litigation and how to avoid that. So I'm Helen Gibson. I'm Agencia's Managing Director. And Agencia have been doing health and social care work for almost 23 years now. So we've got a huge track record in working with a whole wide range of clients. But ReWire is something that we set up just over 4 years ago, and that's been specifically to address the issues that we found where people have come across being at risk of addiction and misuse of painkillers, and our services and training and support packages have helped and continue to help in terms of actually addressing that and helping to reduce people both getting started in terms of that risk of addiction, but if it does get to addiction, then actually what can be done in terms of helping and treating as necessary. So that's our brief introduction to myself. We've got Majid Hassan from Capsticks here today, who is a partner. And Majid, perhaps you'd like to just say a small amount about what you're doing and your background, particularly with relevance for today and the topic that we're talking about.
Thank you very much, Helen. And first of all, I'd just like to say I'm delighted to be involved in presenting this session with you and with Agencia. So thank you very much for inviting me. Yes, I'm a solicitor specialising in clinical negligence, a partner at Capsticks. We work for the National Health Service as well as other insurers. My own area of specialism has been around general practice and supporting all those who work in general practice in the defence of clinical negligence claims. One of the areas that I've certainly had experience in is looking at prescribing errors and how that can be addressed. Obviously, really important issue in terms of painkiller addiction, and I'm looking forward to sharing some information on that with you today. Thank you.
Okay, that's brilliant. Thanks, Majid. So without further ado, we'll share our screen now in terms of a couple of slides that we'll go through. So just bear with us for a second. Okay, so here we've got the just a brief introduction, which we've partly covered, but obviously for ReWire, it's all about switching off painkiller addiction. And this specific session, as we said, is how we can actually really focus on trying to reduce the risk of litigation. We've introduced ourselves, but just so you've got our names and the jobs that we're doing, here's a slide on that. And then I just wanted to touch briefly in terms of our work with ReWire as a whole. So we've been doing this work for just over 4 years now, and that includes delivering a whole range of services to help try and switch off painkiller addiction before it either gets to that point, or if it does get to the point of addiction, then how we can actually look to treat and work with people on that. So I say a number of packages, but through from the full service provision to a lot of educational work, training in terms of developing the skills of primary care staff particularly. We've got a hands-on assessment package, which is all about actually working with people right through from identifying those that might be at risk of addiction through to the training packages, and I say right through to the full service provision if an organisation actually wants that full service to treat the end-to-end treatment package. So a whole range of things that we're doing as part of ReWire, and for us it's been an area that's been extremely interesting, and one that is obviously very topical, and a real need that we've identified, hence introducing the ReWire service when we did, and wanting to continue to grow and develop that. So that's just a little bit more about ReWire and what we actually offer. And then, as we say, the particular focus for today is that risk of litigation and what can actually be done to try and minimise the risk. And we'll talk a bit more about that now.
Thank you, Helen. So if we look at the overview, really, of what I'm going to be talking about today, these are the key topics. We'll start by setting the scene a little bit. In terms of opioid litigation in the US. Many of you will have read about this, and I suppose the question is it something which could happen here in the UK? And if it did, what would that involve? Also, look at reasons behind potential litigation in the UK, what may make it more litigious over here, what could bring about the litigation, what are the tests for establishing negligence in England and Wales, and the likely reasons for those claims. How do prescribing claims come about? What are the common features behind those types of cases? And then finally, I'd just like to touch on what can be done to try and prevent litigation. And we talk about litigation, obviously it's about preventing the incidents in the first place and preventing harm, avoiding addiction. So really looking at what can be done within clinical practice. Before I go on to the first slide, I just want to look at some statistics actually, and give some statistics that I've read in preparing for this session. There are almost 400,000 people who died in the United States alone since 1999 as a result of opioid addiction. That works out at about 50 people per day, which is really a staggering human cost. In the US, it's figured that it could take almost $17 billion or 12 million pounds and 30 years to cure the opioid crisis in Oklahoma state alone. Oklahoma is one of the areas where we will look at where the litigation, one of the main cases arose. If we look at the UK, a UK study revealed that 500,000 people have been prescribed opioid-based medication for a period of 3 years or more. We are the fastest growing country for opioid addiction behind Israel and Slovakia in Europe. So there's some really sobering statistics there. But if we can look at the opioid litigation in the United States first. The key case, just to mention very briefly, without going into the facts of it, is the Johnson & Johnson litigation. And these were group litigations against Johnson & Johnson, the drug manufacturer. And it centered upon the adverts, which it was felt misled users, as well as those who were prescribing the drugs, over the safety of the drugs and the levels of safe consumption, and this led to addiction. The reason why this was important is it was the first judgment to hold a pharmaceutical company liable for contribution to the opioid endemic. And again, it was a decision which emboldened others in the United States, and I'm sure there will be additional litigation as a result of this. And it also sparked interest on this side of the pond because people looked at it and thought, well, could that happen in the UK? And that's something we will come on to. Part of the reason for the litigation is that it was felt Johnson & Johnson had extolled the virtues of the drugs without at the same time giving suitable warnings or information to those who were administering the drugs as to the possibility of addiction. Damages that were awarded were $572 million US That's a staggering amount. There were potentially 2,000 more cases still in the wings in the United States. And the final point I should say is this was a claim that was brought under public nuisance, a rare allegation, but it was argued that it was a public nuisance because the actions of Johnson & Johnson endangered communities by oversupplying opioids. So cases can also be brought sometimes in negligence, they can be brought in fraud, but these particular claims were brought as public nuisance claims, and they succeeded on that basis. I should just briefly add before moving on, these weren't the only cases that have been brought in the States. There have been other cases brought, but this was the first case that really reached the courts, and that led to the very high award when Johnson & Johnson contested the litigation. There had been a previous case in Oklahoma back in 2004, drug manufacturer Purdue. They settled a case alleging inappropriate marketing of opioids, and that case was settled for 10 million. But that was a case that was settled out of court. So going to court certainly cost Johnson & Johnson a great deal more. If we look now at a comparison of damages awards in the United States compared to America, the United States has very high awards. We often see cases reported which run into the millions. They have punitive damages over there that can be awarded at the court's discretion to punish a defendant in some way. But I think it's important in this particular case that I just mentioned, the Johnson & Johnson case, it was brought under nuisance. There wasn't a punitive damages award in that particular case. The damages that were awarded were tied to the cost of remediating the nuisance. So in this particular case, the judgment specifically was specifically tied to remediation based on public health. So that's interesting. Also, in the States, there are jury trials in civil claims, and that can mean that cases can be more emotive. An advocate can very much pull the heartstrings of the jury and play to the jury, but they can be much more emotive. We don't have jury trials in England for civil cases. Large class actions are much more common in the United States. There have been class actions in England. We've seen the PIP litigation, the PIP breast implant litigation, and other actions, but certainly more common in the United States. Another differentiating factor is that each state will have its own legal system. So, and the jurisprudence, the legal thinking around each state's jurisdiction will vary. In England and Wales, it's governed by one set of rules, one law. So again, another point of difference. And as I mentioned earlier, the claims in these cases were brought as claims for nuisance, and the defendants, as I mentioned, were paying the cost of remediation. If claims were brought in England or Wales, it's likely that they would be focused around negligence. It's likely that those claims would be brought against the manufacturers, the suppliers, and possibly those who administered the drugs. So that would be those working in general practice potentially. And those claims would be brought in negligence, so slightly different there. If we look now at the medico-legal landscape in England, and why could such a crisis happen over here? Well, there's a number of factors I think we need to look at. Firstly, the rising levels of addiction and changing socio-economic factors in England and Wales and Scotland. There are rising levels of addiction, that's been reported. Public Health England published an inquiry in September 2019 which suggested that prescriptions were now handed out to 1 in 8 of adults, and these are prescriptions for opioids were handed out to 1 in 8 of adults. In 2017, there was also a study which recorded that the number of people with prescriptions for such drugs were up by 10 million since 2007. So huge increase in numbers and the factors there that we can see. There's also been extra pressure on those working in primary care. They're seeing far more patients, seeing with far fewer general practitioners as well. So the pressures upon those working in general practice has been well documented, and there are more patients now who've been asking for these drugs as well. Group litigation, as I mentioned, is not uncommon in England, and it can follow a similar path to the United States. We have, as I mentioned, had litigation around the PIP breast implants, and there has been other litigation as well. And it's quite possible that if there was to be any opioid litigation, it would be part of a class action or a group litigation. And the benefit to that for claimants is that they can bring a claim and have a number of test cases going forward. And if the cohort of test cases may be 10, it may be 50, but if the cohort of test cases succeed on the principles in those cases, then it's very likely that all the other claims within the group could also succeed. It's a mechanism which is designed to limit legal costs, and the courts will favour it where there are large numbers, often over 1,000 claimants, all with the same type of claim. So that could happen. Another really important factor to consider is the doctrine of informed consent. In the United States, the principle of informed consent has been around for many years, many decades. In England and Wales, while we've had consent, the true informed consent approach has only been adopted in the last few years, but it is now the law. Doctors, when prescribing drugs or when undertaking treatment and having to obtain consent, need to consider what is a material risk to the patient in front of them. And to do that, they need to understand the particular factors that are important to that individual patient. Not what would other doctors do in these circumstances, but what is important to this patient. What do they want to know about the drug that I'm going to prescribe them? What does this patient want to know about long-term problems, long-term consequences, and has that information been given? Because if a claim is subsequently brought, the claimant will argue, had I been told of the risk of addiction to this particular drug, I would not have agreed to take it, and I should have been told. So that's the basis, and that's very similar to what we have now, what we have already in the United States. So the basis of any claim, although the claim in Oklahoma that I referred to against Johnson & Johnson, that was against the manufacturer, and it is quite possible that any claims in England and Wales could also be brought against drug manufacturers. It's certainly possible that claims could also be brought against those who supplied the drugs. In the PIP litigation, that particular group action, while claims were brought against the manufacturers and the importers and the suppliers of the implants, they were also brought against the surgeons who chose to use that particular implant in procedures that were undertaken. So for that reason, I think it's the reason we're considering how can those working in general practice be involved, and what do they need to think about. And as I've just said, claimant representatives can bring those claims both against big pharma companies as well as primary care providers. So we need to look at what the basis of those claims is and what is the basis for establishing negligence. So if we can look at that now. To establish negligence, a claimant has to show that there has been a breach of duty. When we talk about a breach of duty, we mean that the care provided fell below an acceptable standard. That standard is judged by what a responsible body of general practitioners in this instance would think appropriate. If there has been a failure, that isn't enough to get the claimant home on their case. The claimant then has to go on and establish the second limb of their case, which is that the failure in question, the failure in the care provided, has been causative, that but for that failure, the claimant would not have suffered the injury, loss, or damage which they now allege they have suffered. So in the type of case that we're looking at, a claimant may, for example, put together a case saying, I was prescribed these painkillers over a protracted period of time, many years, as a result of failure by my general practitioner to review the prescription, to review how the drugs were administered. I've become addicted, I've lost a job, my life has been affected in other ways, and a financial claim for compensation is put forward on that basis. And the aim of the compensation is to put the claimant in the same position that they would have been but for the negligence that is established. And the final point to really bear in mind, again, an important point I touched on earlier, is that the issue of liability and whether there has been any negligence, whether the defendant's general practitioner or other defendants has been negligent, as well as the issue of the award of damages, is decided by a judge alone. There is no jury involved in any of the cases we have in England and Wales. It is simply decided by a judge. And the judge will listen to expert evidence, to witness evidence on the issue of liability from all parties involved, and will make a ruling on that. And if it is found that the defendant is liable, there has been a failing in care, then a judge will award damages with reference to awards in other cases for addiction, for losses that have been pleaded, as well as with reference to guidelines around the level of awards and what should be claimed. But that is essentially how negligence would be, and claim for negligence would be brought, and what a claimant needs to establish to bring a case. So what are the potential allegations against primary care providers? Well, I suspect that the primary allegations will centre around the argument, did either the pharmaceutical manufacturer or distributor, or indeed the general practitioner, warn the patient, or did the distributors warn the GPs through clear labelling and product information? What guidance was given on how much to prescribe and how long it was to be given for? So incorrect prescribing is often a central allegation around any type of claim that is brought. The failure to warn of risks, in particular the long-term risk that I mentioned, looking at informed consent, the long-term risk of addiction, that is a key allegation. Any claim against a general practitioner will almost certainly have that at the crux of the case. Often we see in cases around prescribing that there's been a failure to review, a failure to follow up the prescription. Sometimes the wrong drug can be given. Sometimes there's been a failure to follow up the prescription. There can be a failure to warn of allergies, side effects. But incorrect repeat prescribing is often what it will come down to. So a patient may not have been reviewed for a number of months, if not longer. And there could also be a failure to follow national guidance around prescribing. And it's not unusual for any claim that is put forward on behalf of a claimant to refer to national guidance and say, well, there hasn't been an appropriate review of this patient's care in accordance with the national guidance. I appreciate guidance is guidance only, and some may argue there are reasons to depart from guidance in certain situations. And if that's the case, fine, but it has to be very clearly documented if we are departing from guidance, and the reason why, particularly when it's national guidance, the reason why there is that departure. There have been reports already in reported cases in the media around opioid addiction. In one case, patients were being given repeat prescriptions for 2 years without having to revisit the GP. That related to painkillers. So these are articles really that related specifically to painkillers. In another case, a single general practitioner was noted to have had 10 patients in their practice who were addicted to synthetic opioids. Mm-hmm. So it's the long-term prescribing, it's the repeat prescribing, which will often be the focus of the allegations that are put forward. a good example of looking at prescribing issues is really this case study that I'd like to just refer to. So this was in relation to steroid eye drops, but this is a common type of case in the years that I've been dealing with claims arising from general practice. In this particular claim, steroid eye drops were prescribed over a period of 10 years. And the notes indicated that the prescriptions were issued on a repeat basis by the general practitioner without any clinical monitoring or review. The patient had quite easily been able to simply call the practice and get a repeat prescription. There had been no system for review, whether that was because the patient fell through the net, there was no reminder on the system to bring this patient back in for a review, or some other reason. The fact is there wasn't any review undertaken, and no one thought about, gosh, what is the long-term effect of keeping this patient on these steroid eye drops for such a lengthy period? What happened was that the claimant unfortunately developed severe headaches, visual disturbance, and was found to have acute glaucoma. And the experts in the case came to the conclusion that on the balance of probability, it was found that these problems were caused by the prescription over the previous 10 years. So they were steroid induced. And the claimant was successful in the case. They successfully recovered damages and costs for bringing that claim. And it was very difficult to establish and state that there had been no negligence, when clearly all the records showed that there had been no review of the prescription. The prescription had been easily repeated without anyone considering what else needed to be done. So what can be done finally to prevent litigation relating to painkiller addiction? The first point to say, at the moment, there is very little litigation. That doesn't mean there won't be in the future. First and foremost, following clinical guidance is important to prevent the harm in the first place, but we'll come on to litigation. On the subject of what can be done from the clinical perspective, again, it's interesting if one reads some of the initiatives that have been proposed in the United States to deal with their problems around opioid addiction. One article I read said that doctors should require specialized training for all opioid prescribers. They should ensure that there's monitoring and testing for opioid prescribing practice, and that it's an integral part of every program of training. They should develop quality metrics around prescribing opioids and ensuring that the data that's obtained from that is properly mined, is properly reviewed, and the results are published. Adopt effective patient education programs, and that is so important. And the point I mentioned earlier around informed consent feeds into that, feeds into the issue of patient education and making sure patients are aware of what the drugs that they are taking, the risks they have, the long-term risks they have, as well as the reasons for ensuring that there is a regular review. And finally, implementing a protocol for patient intervention for those who are suspected of developing a dependency. What should be done? How can we manage those patients better? I don't want to teach anyone to suck eggs. I'm going to look at it from a legal perspective as reducing litigation, but those are certainly issues that would apply anywhere in the world, really. But from the perspective of a lawyer who is faced with a claim, and in my practice I only defend claims against general practitioners. First, these are some headline points that we would really look at considering. Has national guidance been followed? Is it clear that the prescribing practice was in accordance with that national guidance? Has there been any kind of risk assessment undertaken before prescribing started? Did we look at the particular patient in front of you and look at their history? Is there anything within their medical history that would suggest there may be an increased risk here? Some patients may have come from another surgery Have we got all those notes? Have we reviewed those notes to ensure that there is no risk already in the records that we should be aware of? Prescribing in limited doses, that can help. That can ensure that when that dose is finished, the patient comes back before the practice is reviewed again, and again a risk assessment may be undertaken. Another conversation may be had with the patient to decide how much more should be given, if any at all. The regular review and follow-up is really important. If we have a set of records that show that there was a period of regular review over months or years, and decisions were taken every single time, a risk assessment was done again, that helps massively in showing that the care provided was appropriate. These are all the questions which any expert who's asked, and it would be a general practitioner, to comment on breach of duty. These are all questions which any expert asked to comment on the case would be looking to address. And if they can refer to a regular review, regular follow-up, and most importantly, clear records. Clear records showing the discussions that have taken place, clear records showing the risk assessment that's been undertaken, questions that have been asked by the patient, information that has been elicited, and the decision-making process that has been undertaken. So the more information there is there, the better. And finally, providing appropriate information that ties in with the last point, making sure that there has been an informed conversation with the patient, a two-way conversation, ascertaining the risks and making sure the risks are explained, ascertaining all the information that can be from the particular patient, so that that can be covered. And as I say, once again, making sure that that is all very clearly documented in the records. I feel I've painted a rather depressing picture. I mean, I did also read, just to finish, one statistic that showed despite the increase in prescribing of opioids between 2008 and 2018, over the past 2 years, prescribing of opioids has gone down in the UK. So that is certainly something which is good. And I think if manufacturers, as the litigation in the United States has shown, if manufacturers, distributors, those working in primary care haven't acted now, I think they definitely need to. I think we need to act to ensure that there's clear instruction, labelling, information to patients, showing that they are alive. All of those people, and certainly general practitioners working in primary care, need to show that they are alive to the risks of opioid addiction and managing their patients accordingly as a result of that risk. Thank you. I hope that helps, Helen. Any questions you have?
Yeah, thanks, Majid. That's been excellent, and some really very, very useful stuff. So thank you so much. And yes, I do have a couple of questions for you, if I may. And there are things that we're finding are coming up time and time again with the work that we're doing with GPs, staff in primary care through our ReWire service. So if you're happy for me to ask just a couple of questions, that'd be
Absolutely.
super.
Absolutely. Fire away.
So, I mean, question number one is, as I say, a question that comes up time and time again, and it's around the fact that many GPs say to us that they're actually worried or reluctant to raise this issue of potential misuse of painkiller drugs, and therefore it's something that is perceived as being potentially quite a difficult conversation to have with our patients. So, I mean, is there any advice that you can give for GPs or those of us that are in the position of having those potentially quite difficult conversations with patients that would actually help us to raise that issue in the best possible way?
That's an excellent question, and I can see how it would be something of concern to all those in general practice. I think the key thing to appreciate is you need to have an honest and open conversation. It's a difficult topic, but it's a really important topic. Many years, claims are brought often many years after the event. And if a claim is brought, it's almost certain that the person bringing the claim, the patient, will say, well, if I had been told, I would have acted differently. I wouldn't have taken that drug. I would have asked more questions, etc., etc. And it just wouldn't be sufficient. It wouldn't give us enough to mount a defence to say it was a difficult conversation to have. The patient certainly won't accept that. The patient will say, well, it was a difficult conversation, but it was incumbent upon the general practitioner to raise that with me as the patient. I wouldn't have known about it as the patient. It was incumbent upon you to do so. And I think that comes back into the point about making an informed choice about the treatment that the patient receives. And to make that informed choice, they have to be fully aware of the benefits of a particular treatment, but also the risks. And when we talk about risks, we mean short-term as well as long-term risks. Any conversation with the patient should include something along the lines of, well, if we don't give you these particular drugs, then this may happen. And that may be fine. There may be other alternatives to manage that pain for the patient that don't involve drugs. And all of the options should be clearly set out. You need to consider this from the patient's perspective. My best advice to anyone in general practice would be to say, put yourself in the shoes of that patient. What would you want to know? You would want to know, what are all the options? What are the short-term and long-term risks? What are the benefits that this treatment gives me? How do those benefits weigh as against the risks? And if you can have that type of conversation, I appreciate in 10 minutes, it's not always easy, but if you can have that type of conversation, it's important. It's very important. Yeah. And that's what should be done.
Yeah, no, that's brilliant. And again, really helpful, Majid. So thank you. And my second question is, it's a good one, but given all your experience and everything else, in terms of top tips, if you were to say to somebody, oh, my top tips for avoiding or really trying to reduce the risk of possible litigation, what would be your couple of top tips for us?
Okay, sure. So I suppose really just some of the things that I've picked up in the talk, just going over a couple of points. Firstly, making sure that there is, as I've just said now, the right type of conversation, informed consent, that there's a two-way conversation being had. You've given the patient the information, they've understood it, they've asked you questions. So evidencing that, making sure that that can be seen from the records. So that type of conversation before any prescribing takes place. Secondly, making sure that you have appropriate systems in place to review the prescribing. That is fundamental in nearly all of the cases that I've seen around steroid eye drops, of which there are many, I'm afraid. Often there has been that failure to follow up, to review the patient after the correct period of time. So patients have been given repeat prescriptions. Sometimes they've just been lost to the system. No one has thought about saying, well, actually, we need to bring you back in and reassess whether this is appropriate. So that's my second point, making sure that you have a proper system for reviewing what you're doing and the decisions around prescribing. And finally, the most important thing, which I'm sure all of your members and all doctors get tired of lawyers saying, is making sure that it's evidenced in the notes. For us, the only thing we can rely upon as lawyers is what's contained in the notes. If cases get to court, sometimes judges may adopt a starting position that, well, if it's not recorded in the notes, it wasn't said. And the patient will often have a very clear memory. It may be a particularly important consultation for them. They may remember when they first went onto this drug, and the patient will say, well, I remember that consultation and I definitely wasn't told it. And if there's nothing in the notes, it's very hard for a doctor to say, my standard practice would be to inform of that and I probably would have informed that patient of the risks on that day when, you know, that general practitioner, that doctor may have seen 20, 30 other patients that day. So making sure it's evidenced in the notes from a legal perspective is actually one of the best ways to ensure that if litigation is brought, that it can be successfully defended.
And again, extremely helpful. So thanks so much. I think we've just got time for a final question, and then we'll finish up. But sure. That final question, if it does get through to the situation where the case is proved, and what sort of damages might you be sort of looking at or expecting if damages are awarded in a case like this?
That's a really good question. It depends how the case is brought. Whether it's brought as part of a group litigation or as an individual case. Group litigation, obviously, in some of the group litigations that have happened in the past, the defendant has agreed to award a certain amount of compensation to the whole group, and then that compensation would be split between the group. But if you look at an individual case on its own merit, if an individual case is brought, it will really come down to saying what are the particular heads of loss in this case. So some damages will be awarded what we call general damages for pain, suffering, loss of amenity, and that's for the addiction itself and the effects of that on the individual. That may be disturbed sleep, that may be some level of psychological trauma or otherwise. And then on top of that, there may be damages that are claimed if, for example, the addiction has led to a loss of employment. The addiction has led to other financial losses, and those legal representatives on behalf of the claimant will need to specify what those losses are and put the case forward in that basis. So it's difficult to say it would be worth this amount, but it's really looking at each case on its own facts and how the addiction has affected this particular claimant.
Yeah, understood. And again, I'm sure really helpful for people just to understand that a bit more. So thank you very much. So, I mean, those are all of my questions, and it brings us to the end of our time together. Just a quick recap in terms of our contact details. And obviously for Madrid and myself, in fact, I'll come out of the slide share just so that you can see us. Obviously very happy to hear from people and share our experience more broadly, and of course happy to help, whether that's on the legal side or for myself through ReWire, whether it's identifying possible risks, whether it's the education and training, or whether it's actually providing a service that can actually give that treatment that might be needed on occasions. So thank you very much, and it's been an absolute pleasure, and hopefully useful to everybody. Anything else from you, Madrid, or otherwise?
No, it's just really grateful that you've invited me to come and talk on this really important topic. And so my details are there. Very happy to answer any questions for anyone looking at this video. So thank you.
Thanks very much. In that case, we'll sign off and say thank you very much.
Thank you. Bye-bye.
Bye.